Breaking Down the Law is sponsored by Battle-Born Injury Lawyers.
Okay, so we are taking a live look right now at the Senate confirmation hearings underway for Judge Amy Coney-Barrett. That's President Trump's nominee to replace the late Justice Ruth Bader Ginsburg. Day 3 of the process, and no doubt another long day of questioning from lawmakers. Lasted some 11 hours yesterday. One of the most talked about issues during the confirmation hearing and leading up to it for Supreme Court nominee Amy Coney-Barrett centers on the Affordable Care Act. Democrats claim that the ACA is deemed unconstitutional. Millions of Americans will lose their health insurance and protections for pre-existing conditions. So what are the chances the health law could be overturned, and what can it mean for people in Nevada? Well, here to discuss it all, attorney Matt Hoffmann with Battle-Born Injury Lawyers. So Matt, first of all, let's start with the upcoming, well, obviously the hearing is underway right now. What is that issue, and what is the likelihood that the Affordable Care Act could be deemed unconstitutional?
Yeah, and you know, the case itself that they're referring to is on November 10th. There's a hearing on California versus Texas, and I could spend a half hour or an hour talking about it. But the quick on it is that you had the Affordable Care Act previously challenged as unconstitutional because of the individual mandate. You either have to buy insurance or you get taxed for not doing so. The U.S. Supreme Court said that that was constitutional as a tax. And so Congress was within their power to tax you. Well, that went away in 2017 with the tax cuts. And so it was challenged again, saying, hey, without this mandate, it's now no longer a tax and it's unconstitutional. The district court in Texas agreed, the Fifth Circuit agreed, and they deemed the entire law to be unconstitutional because of that one provision being unconstitutional. So now that's coming before the Supreme Court. It's going to be heard on November 10th. And the issue really is going to be, if that one portion is unconstitutional, does it mean we have to throw out the whole law? Or can that one portion be separated from the remainder of it? I would say that based on recent decisions by Justice Kavanaugh and Roberts, they seem to favor severability, so saving the rest of the law, even if that portion is deemed unconstitutional. But the concern that you're hearing from a lot of politicians is that, hey, you know, the Affordable Care Act could just be thrown out. And I find it interesting that if Judge Barrett did not become a Supreme Court justice and it was a 8-person Supreme Court, let's say it went to a 4-4 tie. Well, what that would mean is that the Fifth Circuit's ruling, because it's a tie in the Supreme Court, it would stand. So now the ACA would be unconstitutional within the Fifth Circuit, Mississippi, Louisiana, Texas. But I mean, I don't think that's going to happen. I think she's going to get confirmed. I just don't know the likelihood that the whole thing will be deemed unconstitutional, but it certainly could happen.
Okay, well, let's go to that extreme. Let's say that maybe it does happen. What does that mean for coverage? I mean, it brings up a lot of questions.
Yeah, it does bring up a lot of questions. I think the biggest one that we're hearing from the politicians is, hey, protection for pre-existing conditions are gone if the ACA is deemed unconstitutional. And that's pretty misleading, to be honest. The Affordable Care Act did not invent protections for pre-existing conditions. Pre-existing conditions have actually been protected for over 24 years. That was the Health Information Portability and Accountability Act, HIPAA. HIPAA was a Republican bill that was signed into law by President Clinton in 1996. Now, most people know it for the privacy portion where, you know, like in my business, I can't get somebody's medical records, my own client's medical records, without an authorization to do so. But the biggest impetus for that bill was the portability portion. Back in the mid-90s, a lot of people were trapped at their jobs. You know, let's say you've been working somewhere, you have insurance, but you have a heart condition. Well, you don't want to switch jobs because it would mean you'd have to switch insurance plans, and then now they don't have to cover that pre-existing condition. HIPAA did away with that. The condition is you have to have had 12 months or more of continuous health coverage with another plan without a break of more than 63 days. So the reason I bring that up is that anybody who's currently insured through the Affordable Care Act, if it was deemed unconstitutional and they were forced to now get a new plan, as long as they had 12 months or more of coverage through the Affordable Care Act, then the new insurance plan could not, because of HIPAA, deny those pre-existing conditions. And, you know, and as an aside, from a political standpoint, it seems that the protections for pre-existing conditions are pretty popular. Even President Trump has spoken out in favor of them. So I think that if it's deemed unconstitutional, I think there would be some kind of legislative action to preserve that portion.
All right, Matthew Hoffmann, we appreciate you. All eyes are watching and waiting to see if Amy Coney-Barrett will be confirmed, and then ultimately what happens on November 10th with California versus Texas. So we appreciate you for breaking it down, helping us understand it a little better. We'll see you next Wednesday.
All right, thanks for having me.